I'm also in a place you might hear a little background noise, so I apologize for that. There's a little music in the background. And maybe a voice or two. Anybody got a contract question they want to cover before I get into my stuff? Okay, I'm speaking up. Everybody can you hear me? Yeah, okay, good. All right. So question came up whether AVID was required. We have a transaction where the buyer came through a lender who was in Southern California. The buyer found the property. The lender turned him on to his brother, who's an agent with a firm in Southern California. And the agent down there wrote up the contract for this buyer. But isn't from the area, doesn't want to come to the area. So we're representing the seller, and we're requesting an AVID from this buyer's agent as part of the transfer disclosure statement. And the AVID itself is not a statutory document. However, I'll read you what our attorney says. Civil Code 2079 requires both the seller's agent and the buyer's agent in a residential 1 to 4 unit property to conduct a reasonably diligent inspection of the property and to disclose in section TDS section 3 what they discovered. It's usually done on an AVID, but it's not necessarily, it doesn't have to be done on an AVID, but they do have that statutory obligation. This is a statutory duty, and a failure to do so can lead to civil liability and also a DRE license violation. A buyer's agent's AVID has no effect on it being a completed TDS for the purposes of commencing the buyer's right of cancellation. So the fact that we don't have it doesn't give the buyer an additional right to cancel. There is no additional liability to the seller's agent if the buyer's agent doesn't do their statutory duty. It would be a good idea to point out to your seller that seller is entitled to a buyer's agent AVID or equivalent. Where it would play out is if there is a claim after the close of escrow, the buyer's agent can be made to look negligent or worse. So we just passed that information on to that buyer's agent and said, okay, you don't want to do one. You don't want to come up here and look at the property. You don't want to do a visual inspection as required by law. You can choose to do that. We're going to advise our seller that they're entitled to an AVID from you or a disclosure from you, and that you aren't willing to give it. So we just want to let you know. So that's kind of how that ended. Any questions on that? Okay. Counting days came up. How do you count days when, it says 17 days to complete your inspections or 17 days to get your loan approval, those sort of things. And I can't pull up the contract, but in the RPA, under the definitions, towards the end of the contract, there's the section called their definitions. And one of the longer definitions is counting days. And it tells us exactly how we should count days. And generally, it's the day 0 is the day the contract is completely ratified. And that's not the date that it's last signed, but the date that it is delivered to the party after it is last signed. So you could go out at 9 o'clock and get client to sign the agreement, whether it's a RBA or a counter offer or whatever it might be, and then you don't deliver it to the other party until the next day, well, that's day 0 then. And then you start counting the day after that. So 1, 2, 3, so forth. And when you're counting days, you count all days. However, there's certain things that can happen on a weekend or a holiday. So if you're counting your 17 days to contingency removal and it lands on a Saturday, well, that's moved forward to Monday, because it can't, the performance of one of these contingencies can't happen on a weekend or a holiday. So it would move forward to the Monday. If the Monday were a holiday, it would move forward to Tuesday. So it's all spelled out very completely in the RPA. And as Bill, our broker risk management counsel, is very very frequently, if we read the documents in their entirety, we usually find out the answers to our questions. So read away. That's the important thing. Any questions on counting days? Okay, good. 3, we're representing the seller of a duplex, or actually there's 3 rental units on the property. And he has month-to-month rental agreements with all parties, all the tenants. And the buyer wants to take the tenants along with the property. He wants to keep them in place. So the question comes up about what forms we use to do that. Well, there's the new form called the TOPA form, TOPA. That's tenant occupying in possession addendum or something like that. And that spells out a number of things about the tenants, whether the tenant's going to stay in possession or whether the tenant's going to be vacated. So that we should be used to TOPA, because that'll spell out between the buyer and the seller what's going to happen to the tenants. So in this case, the TOPA would say that the tenants are going to stay in the property. And then the question of getting the tenants to a turn or to pay their rent to the new owner, we can use the assignment of agreement form. So the leases are an agreement that can be assigned by the current seller to the new buyer. And then those assignments would be given to the tenants, and they would now direct their rent to the new buyer. So we would use those 2 forms to affect the transfer of those tenants, basically from the seller to the buyer. Any questions on that? Okey-doke. Question came up recently. It comes up pretty often, actually, about arbitration. There's 2 paragraphs in the contract where, besides signing at the bottom of the page and signing at the bottom of the contract, there's initials required on 2 paragraphs. It's the liquidated damages provision, and the second one is arbitration. And these are separate signatures that are required by both the buyer and the seller for those particular paragraphs to be effective. And if those aren't signed in concert, that is, if both parties aren't either initialing or failing to initial those, then we have a hole in the contract, and we don't have a completed contract because we don't have a full meeting of the minds. So it often comes up that the buyer will sign arbitration, they'll initial the arbitration clause, and then the seller will say, well, I don't want arbitration. So what do you do in that case, Rob?
Good question.
Come on, you know what to do.
I'm sorry, I was distracted by a text message.
You were reading your email. Okay. Okay, so we have the buyer submits an offer and they've initialed the arbitration section of the contract, the RPA. But the seller doesn't want that. So what does the seller need to do?
I mean, the seller's not required to sign it, but I actually don't know.
Okay, anybody else want to jump in there?
What I've always done is you have to do a counter. You have to counter it. You have to counter it.
That's correct.
Yeah.
There has to be a meeting of minds on that issue. So even if you have no other items in the contract to counter, you have to counter back on the arbitration. Say the seller would counter back and say arbitration not to be part of this agreement. And I always like to reference the paragraph that you're referring to in a counter offer. So you say arbitration paragraph 38 or whatever it is, not to be part of this. And then once the buyer signs the counter offer and gives it back to the seller, then you've got your ratified offer. Okay. Thank you, Yvonne. See. NHD form. We got an interesting new form, and I always say I love this business because there's always something to learn. So we got a form we'd never seen before. And that's it was just it was from a Coldwell Banker office. We representing the seller, they're representing the buyer. They gave us a form that wanted us to, our seller to sign, and it said that the NHD that the seller was providing to the buyer was exclusively for that buyer or obtained on behalf of that buyer specifically. And it had some other language in it. It was a full page of stuff. And we never saw it before, and we don't know why, you know, it was, you know, the buyer, you know, the brokerage wanted this. But we sent it up to Shannon and Bill, and they sent it back and said, this is ridiculous, it's unneeded, and don't fill it out. So I think what they were trying to do was say that the buyer, because they were relying upon the NHD that was ordered by the seller without a specific buyer at the time, because they'd ordered it prior to this buyer coming on the scene, they wanted it to be that it was for that specific buyer, so the buyer would have rights, challenge rights against the NHD company. Interesting theory. It would seem that the NHD is actually fulfilling a seller's disclosure and not an independent disclosure that the buyer, if the buyer felt that the disclosure was wrong, they would file some claim or something against the seller saying, hey, you gave me a bad NHD report. And then we would go to, you know, the NHD company, which gives us all kind of warranties about the work and blah, 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 and say, here, take care of this. So it was a superfluous form. It was one that wasn't necessary. And we don't like to do forms that aren't necessary in the documentation. So we just told that broker and agent that, no, we don't want to do that form. And Curtis is asking, was that buyer an attorney? No, it was actually the brokerage that was asking Curtis. So, but it's the first time we've seen it, so it was interesting. I did have a case a while back where, in fact, we're in actually in one of the, it's the only lawsuit that kind of we're dealing with right now, was where the the seller obtained a termite report, and gave it to the buyer, and the buyer didn't get their own termite report. And then the buyer tore the house apart and found there were termites hidden behind the walls, which of course the termite inspector wouldn't have known about because they don't open up walls and so forth. So, and they filed a lawsuit against us for non-disclosure of those termites that were behind the walls, or against the seller and us, and then also the termite company. So one of the termite company's defenses is that, well, I didn't do this report for you anyway, so you can't sue me. And that's a good reason for your buyer to get their own inspections, you know, so that those reports are directly for them. These aren't seller disclosures like the NHD is a seller's disclosure. That's, you know, you could fall back on the seller and say, hey, you made a mistake in not disclosing this. But when you give a report, you've gotten that report as a listing agent, so the seller knows what they're dealing with. So they can expect that, oh, I've got $10,000 of deck work. Do I want to repair that work? Or do I want to give a credit to the buyer for that work? And then because we have it, we give it, right? So we give the reports that we have. But as a buyer accepting those reports, or as a buyer's agent, passing those reports on to our buyer, we still want to advise that buyer to get their own reports. Because I've seen on my own home once, a buyer got a termite inspection, and it called for, I don't know, I was selling my house and it called for $5,000 worth of work. And I said, no, that's ridiculous. So I called out my own termite company, and they did a report independent of the first report. And they said there's $7,500 worth of damage. I said, well, that's worse. So the termite companies aren't always going to agree. And some are known as favoring sellers or favoring buyers. I don't know their names or whatever, but some agents have their favorite. I'll get to you in a minute, Alejandra. Have their favorite inspectors, and maybe those inspectors try to lean in a certain direction. So anyway, if you're representing a buyer and you get reports from the seller, we still encourage you to tell that buyer to get their own reports. Alejandro?
Okay, so how you manage that? I mean, regarding if the buyer comes to you and says, well, we got the report from the seller, should I get my inspection? From then you say yes, and the person says, well, I want to save money. Do you think that it should work? And then it could be like, okay, you say, well, I should say to you that you need to get your own reports, but and then can the buyer come back to you and say, well, you should insist me or say that. Should I put it on writing or?
Okay, so we had this offer. We were representing a buyer in an offer, and they got into contract, and we did have reports from the seller. The seller was a contractor who had done his own flip on the property. So they gave us reports about what they had done and so forth and so on. We encouraged the buyer to get an inspection. They spent $650 on inspections, and the inspection showed that there was $10,000 worth of work that was done incorrectly, or work that still needed to be done. So the seller had made it clear that they weren't going to make any further concessions on the price. The buyer didn't want to buy the property with this $10,000 worth of work still to do, so they backed out of the contract, canceled the contract. That was their right to do that. The weird thing was they came after our agent then and said, you need to reimburse me the $650 for the reports I spent, because I never would have done that if I knew about the $10,000. And it's it's a kind of a circle argument. Well, you wouldn't have known about the $10,000 if you didn't spend the $650. So you should feel happy that you spent the $650. So I would just tell a buyer a story like that. Yeah, you may want to save the money, but we've had circumstances where your reports will discover damage that's far greater than what the seller's reports say. So it's at a risk if you do that. So whether you do that in writing or not, I wouldn't be so concerned, but what you're going to have to defend in court is what's called your standard of practice. And if you get asked, how do you usually handle these things? And you say as the agent, I always tell my buyer to get their own reports. And then I say, they call me on the stand and I say as the broker, we always have our agents tell their buyers to get their own reports. That's our standard of practice. So we can defend those actions. Even if the buyer says, well, they didn't tell me to get my own reports, or they didn't insist I get my own reports. Does that make sense? Okay. And Sherry, yeah.
Yeah, thank you. I had a similar question too. So is there anything we can do to not sign or you said, they wouldn't be signing off on it, but what about like just an acknowledgement that we told them? Would an email trail be okay with that for that?
Email trails is perfect. It's better than verbal one, but it wouldn't be necessary. If it's your standard of practice, we can fall back on your standard of practice, but an email trail is even better.
Okay.
And that reminds me, the email trail stuff that, remember Bill said in the legal update, or maybe it was Shannon, one of the others said, we need to be feeding our emails into the TC's file on a contemporary basis. So if you're working on a transaction, you get it into escrow, you open your escrow, you send the paperwork over to the TC, you start sending your emails from your client, between you and the other agent, you start sending them contemporaneously to the TC. And that would be, for me, I would just put a CC on all my correspondence between me and the client regarding that transaction. You aren't going to send her correspondence about your holiday plans, but if it it's regarding to the property or decisions about the property, just put a CC on there to your TC and it'll go into the file. What she didn't like to see, Shannon said this in the legal update, was dumping all your emails in there at the end of the transaction. And I've been guilty of that myself. You go through a transaction and you're going along and then you're about to close the file out and I send a whole, pile of emails at one time to the TC. Our legal counsel likes us to do it on an ongoing basis as it happens. Okay. Everybody understand that?
Thank you.
It's a little change in the practice that I've done in the past. So personally, I can say. Curtis points out again that these reports, both home inspections and termite inspections, have all kinds of disclaimers in them to protect the people making the reports. So that's going to be a defense in an argument to a complaint of any sort that hey, we've said that this doesn't verify. And you have to be particularly careful in those reports to say I couldn't access the area, or that's usually what it would say, unavailable to access. Sometimes a seller in getting the house ready will stick all of their belongings in the garage, right? So now the garage is all full of stuff and an inspector can't get and look at everything. We've had, when those are pulled out, we've seen stains in the wall, which later led to a leakage, which later led to a claim that, the seller didn't disclose the leak, and complained after close of escrow. So when I was buying a house one time, and termite inspector said I couldn't access the area behind the stucco. And it looked like it was susceptible to rot and damage because it was below a window frame. And so I got permission from the seller to cut open the wall on the inside of the house so we could see the the framing members behind where we cut it open and see if there was any damage. And then we patched it and, made it right again. So if the, additional investigation, when those reports call for additional investigation, you don't do it, then you can't hold the party accountable for it. We recently had a case where it was a foundation, and the foundation was hidden by landscaping. Now, a portion of the foundation was exposed and not hidden by the landscaping. You could see that there was a separation of some structural member from the foundation. There was a gap that wasn't structurally a problem, but it would allow like mice in there or critters. So the inspector had pointed out. Now, what happened was later on, behind the buyer accepted that. And when they were doing the final walkthrough, some of the landscaping had been trimmed or something, and now there was a bigger gap in another area than before. Removal of conditions, so they can't kind of pull this up now and say, we want compensation to fix that. So when there's a note in a report that says further inspection advised or can't access this area, make sure the buyer understands that there could be a problem behind that area if they don't do further inspections. There's a couple questions here. Okay. Yeah, Joe, your question about your invoice, that would have been a Norbar invoice. They did come out last week. Yvonne, isn't that why we use the BIE and the BIW are so important? That's true. So the BIE form is the buyer's elections for inspections. What's the BIW, Yvonne? Waiver inspections?
Yes.
Okay, yeah. So we like to use those forms and get the buyer to check off all those things that they're going to do and acknowledge those things that they aren't going to do. Very important. Good idea. Julie.
Hi, thank you. Do buyers ever ask the sellers to remove items if they're in the way of a full inspection?
Oh, sure.
Is
Sure.
that something that happens?
Oh, yeah. Oh, yeah. Very, very standard. If the inspector, usually a buyer will accompany, and it's good for buyer's agents to accompany the inspectors. Even if the buyer can't, it's a good idea to go for the buyer, the agent. And if the buyer agent or the inspector says, I can't access that area, it could be a problem because there's plumbing in that wall. You go through the steps of saying, hey, we need to access that area. Seller has to make that available. Curtis, there may be they may state a limit of liability, but I don't think that's statutory. If they make a gross error, they're going to be responsible for it. So they may put it in their paperwork, but it may not be enforceable. Okay. Any more questions about what we were talking about? Well, we covered emails into the file. New construction came up. Okay, Sherry on? Okay, so if you're dealing with new construction properties, there isn't a new construction RPA specifically for new construction. There's also a new construction addendum that you can use attached to the regular RPA. And it kind of fills out the gaps of those things that are in a new, that would need to be disclosed in new construction. And there's also a new construction disclosure form. So we want to use all of those if you're dealing in new construction. New construction is a bit special. It's a bit of a specialty item. We don't handle it a whole lot. So if you are working in new construction, make sure you're fully versed in all the forms that are used, in the terminology that's used. They talk about grade of insulation in those forms. I don't know what this grade of insulation is. I took a course on that once, but kind of forgotten. If you told me it was a 30 weight or something, I wouldn't know what that is. So, but if you're dealing in it as a regular practice, make sure you understand those things, and we can get the answers if you have questions about them. Okay. See, is there anything else on my list? I think that's all I got on my list today. I wonder, you all got notice through your agent connection platform about national sales rally that BHG is putting on. And this is for agents from all over the country. It's kind of like a virtual fusion. I know some of you have been to the fusion events in Las Vegas, where all the agents assemble and we get training and we get updates on what's coming down the pike through the franchise and things like that. So that's scheduled for December 15th from 9:30 to 1:30. So it's a half day. But if, I think it's worthwhile, I'm going to tune into it and check it out. So if you aren't out of town or traveling and you can block out that time, I strongly advise you to check out, block out 12:15 from 9:30 to 1:30. It's something you have to register for. You'll be getting additional notices about it as it approaches. I'll put it in my weekly update. That'll be a kind of an interesting, I'm sure to be educational, interesting, and hopefully inspirational, because that's what we like from our folks, right? Okay. So that's all I've got for you today. Any questions? Things we didn't cover? Things we did cover? Yvonne, it's good to see you on board. Welcome. Sharon, welcome. 2 new agents, and if anything comes up in the next week, let us know. I think we're on board for next week, and so we'll have one or two. I think we have one more week before we get into holiday season. So we'll catch you next week. And until then, be safe out there, as they used to say on Hill Street Blues. Take care, everybody. Bye-bye.